We started at an hour and a half already missing the fireworks.
Pointing out this one area. All right, very good. All you were telling your talk. Okay. All right. I'm using.
Come on. Did you know this was 3 minutes? That's all that you're
You, sir, are very fortunate because I was on the agenda at the last meeting and they chose not to hear my presentation on streaming live video recording so that everybody in the county can see the meetings.
Oh, check. Yeah.
That's pretty good, by the way. That's on the cost. My advice, you leave right now.
Yeah.
That's why I'm saying
I want to say hi to Tom. Hi, Tom. Lonnie. How are you doing? How are things going?
Yeah, I like seeing you trying to move on it.
Sure. All right.
Is that your recording device? Yes. Is it in somebody's device? Yeah. We put it somewhere. Why is it in somebody's device? I just wondered if there's a place where we put it.
What's right here?
Wasn't in Supervisor Shirley. You as well responsible.
Let's call on someone to volunteer to do the invocation. Anyone? Okay, ma'am. And afterwards, we'll
in Apache County Jail District in Graham County to house inmates on an as-needed basis. Graham County's facility is not adequate, and we have been housing some female inmates for them. With this IGA, it is the agreement for payment for housing those inmates for them, so that we can be reimbursed.
all right. All in favor, say aye.
Aye.
Aye. Opposed? The ayes have it. 2 in favor, 0 opposed. Thank you.
Move that we turn the transition meeting.
Okay, second motion to adjourn. All in favor, say aye.
Aye.
The Apache County Jail District meeting is hereby adjourned. Thank you. Okay. Now we go to the Apache County Board of Supervisors meeting. This item 1 says District 3 Supervisor discussion possible action on recall to public. Mr. Willard is not here for that. I just want to let the audience know on this. You know, as the chair of the board, I will be putting this back on at the next meeting. So, you know, that's, however, you know, we need to please refrain from criticizing the board. I think that's what caused us, you know, purpose for having the chair take this off the agenda. Now, we're all civil on this, you know, and you know, we'll try it again, but it'll be at the end of the board meetings. Okay.
I would like to speak to this issue on the agenda.
Mr. Chairman,
Yes.
I believe if you're going to remove this item because Supervisor Weller's not here, then there would be no discussion on this if you're going to remove it from the agenda at this point.
Okay, there's no discussion on this.
Started, point of order.
There is no discussion on this. I already said what I had to say.
This isn't about what you have to say, this is about what the public has to say in response to an agenda item that's legally on the agenda. It's officially there and was there when the meeting started.
And what is that?
What is that? A definition of freedom of speech and the reasons why it is protected in the United States under
We're
law.
going to item 2. Community development. Mr. Winger.
Yes, Mr. Chairman, that would be Phil handling this.
Thank you. Good morning, Mr. Chairman, members of the board. This is a public hearing for a possible executive session, if you choose to go into one, for consideration and possible approval of the Greer Zone map, designating those properties listed as Greer Commercial Resort. These are existing businesses that have operated under a non-conforming use or a conditional use and now being designated as a specific zone. A little bit on the history of this. In July of 2010, the Board of Supervisors adopted the final draft of the Greer Zoning Ordinance, Article 6. The intent was that within 6 months we would do this hard zoning, lay down hard zoning, have this map down back then, but several things happened right after that caused that delay. First was a comprehensive plan. We decided to go and work with the University of Arizona and try and create a comprehensive plan. After some in-depth work, they created a master plan, but failed to finish the comprehensive plan. So because of budgets and other reasons, we abandoned the project at that time. Shortly following that, the wall of fire happened, and that also took our attention away from hard zoning in the Greer area. And so we have been working on this hard zoning map for over a year now. Okay? Just to give you an example, we went to the P&Z Commission in January and was voted on in January. It took several months to get it to that point. And we've been working on it for 5 months to bring it to the Board of Supervisors. There's a list of 28 properties that we reviewed. We've recommended a denial on a couple, mostly because the property owner chose not to have that designated as a commercial resort. The rest have chosen, elected to have their properties rezoned as a commercial resort. Supervisor Weller, unfortunate that he couldn't be here today. He sent me several emails over the weekend, one of which he asked me to read. I forwarded it to Beth so she could put this in the record. Let me just go through this briefly for you. Supervisor Weller whose district this zoning issue resides in, has requested this agenda item to be postponed until he can attend the board meeting. I have decided not to postpone the item, as I've worked with the attorney's office and the people involved in this. We've chosen to move forward with this. We had it on the agenda back in April and postponed it then. It would be some extensive delays to postpone it again. Anyhow, Mr. Weller continues that he's had approximately 35 individuals taking the time to express their specific and substantive concerns. He's met with them on several times. He's met with county personnel. He says there's been no communications to Supervisor Weller's office from a single supportive citizen to approve the controversial parcel. There's one parcel in here, 1 acre out of approximately 50 acres, that there's controversy over whether or not it should be rezoned for a commercial resort. And he's received several, and you'll hear from several today that are against that. And we'll have that discussion here shortly. Mr. Weller has asked for and received one visit from the council of the controversial parcel owner, who presented only one new piece of relative information in that meeting. That information has since been placed into question as to its importance or true relevance to the decision before us. Additionally, the item was not unanimous when it went to the board from the P&Z Commission, which adds a level of concern. That vote was a 5-to-1 vote.
Excuse me, Milton. Yeah, that was when? The 5-to-1 vote.
That was in January.
In January.
And let me continue. There's a couple of paragraphs left of Mr. Weller's comments. Although there are several politically sensitive matters that can be put forth as potentially important, such as previous commercial use, private property rights, county actions, creating misleading understandings or threat of litigation and fear tactics, it's my opinion that we as elected officials need to root out the right thing to do legally when possible and deal with any consequences created by potentially wrong decisions in the past. We are, in my opinion, elected to see through the rhetoric and find factual truth when possible. Without the benefit of hearing the final discussions and input at the meeting on the 19th, I can only state the following. At this time, the legal opinion presented by our county attorney's office as compared to all the facts presented to me over the past several months appears to me to do nothing more than take a politically comfortable position that does not clearly show what is legal or not. After reviewing the evidence presented to me, I believe the county is at more risk long-term, financially and ethically, if they decide to approve the controversial parcel or even GCR. I realize that I have no vote in this matter since I cannot attend on the 19th. I know of no proxy system for our board, but I did want my general concerns to be heard. Thank you for listening. He signed it very well.
Okay. I believe we got Joe Young on the phone, and I understand there's another chairman. Scott Rose is also on the telephones. Good morning, gentlemen.
Thank you very much, Mr. Chairman.
Okay, you know, I believe this is something that we need to discuss. It's been ongoing since January of this year, and to postpone it, I don't think that would really do us any good, because that's going to delay everything probably this fall, August at least, and but this is something that needs to be talked about, discussed, and approve or disapprove, whatever the board decides to do. And unfortunately, Mr. Weller, is not here. Some of this nature is very important. I think I would be here, to participate in the discussion. With that, we're going to go ahead and discuss it. Okay. For the this is a public hearing, so I'm going to open the public hearing. And I have a lot of individuals that do want to speak. You'll be allowed 3 minutes, and I'm going to go with 10 that are opposing this. It's not, we can't be repeating ourselves, ladies and gentlemen. If there's anything different, then let's state it. If it's just I oppose it, that's. So with that, Of course, if there's other individuals that are in support of it, I do want to hear that too. With that, first one we have is David Bennett. You come up to the mic and please, for the record, give your name.
Good morning. My name is Dave Bennett, and I'm a 30-year taxpayer, and I'm speaking for 175 property owners through the Beer Coalition. I think that's critical. We are including residential, some business, some resort owners in our membership. As Milt mentioned, for about 18 months we've worked on this together, and we have come to an agreement, I believe, on 27 of 28 of the properties. The one that we are in disagreement on is what we call the CK Cabin Site APN 102.08.021A, and if we could, I'd like to just refer to it to 0210A because of the 3 minutes. You have a packet that we have given you, and this would be something I think is really critical at this stage, and that's to look at reference map number 1. It looks like this. Just to clarify, we do not have disagreement with 001L and 001K, which is what we call the cattle case, existing already conditional use permit approved. That is not in contention. What we are very concerned about and dispute is parcel 021A, which is to what I call the north of cattle case. So I think it's critical that we know what parcel we're talking about. The CK Cabin parcel 021A does not, nor has ever qualified for lawful GCR zoning to the requirements defined in Article 6, Section 601B. The key terms in 601B are 1, that are legally being used, and 2, nightly single-family cabin rentals not located on resort property are excluded. In other words, the property must, number 1, have recognized legal commercial resort use, and number 2, a single-family cabin rental is not qualified for automatic GCR zoning if it is not on a legal resort property. I think these are key issues. The exact wording in the ordinance is, and I'll try and read it quickly.
Okay, 3 minutes is up, sir. Can somebody else continue where you left off? Sure. Maybe the second person that's. I believe I have David Martin.
Would I possibly use my wife's minutes?
Yeah, I declined and let him use my minutes.
Okay. What's your
I
name,
can
ma'am?
get through
Legal
really
minute.
quickly. I'm sorry.
Okay. Continue then.
Rather than read directly from Article 6, I'm going to skip that part. But unfounded assertions that parcel 021A is qualified for GCR are based on speculation.
First of all, excuse me. Stop that. I don't have your.
Sorry.
Okay. Stop it. Okay, continue.
Okay. Unfounded assertions that parcel 021A is qualified for GCR are based on speculation that this parcel was somehow included in the 3rd acre in the 1995 cattle case 1.9 conditional use permit process. In matter of fact, a review of all of the county documents of record in the conditional use permit hearing process for 1995, only a 1.9 acre CUP was applied for, heard by 2 Apache county bodies, and granted a conditional use permit. The documents that you have, and there should be 9 of them, again, only site plan that is ever subject to a public application, a public agenda, public hearing, and a public discussion, and a public decision was 1.9 acres. A 3-acre site plan was never the subject of public application, public agenda, public hearing, public discussion, or granted no development rights. In your packet, you also have April 20th, 1993, stable CUP application. Further examination of the Overacker Stables CUP clearly establishes that the CUP terminated south of the section line between 11 and 14, and therefore was never a legal commercial stable operation on the Sea Cape parcel 021A. In light of these facts presented, parcel 021A has no legal resort use or commercial history, and therefore is not lawfully qualified to be designated GCR at this hearing. Thank you.
Thank you. Okay, next one I have is David Martin. Okay, go ahead and start it, Mr. Winter.
Thank you, Chairman White. All the members of the board, the hearing and support staff, as well as our competition or opponent. Good morning. My name is David Martin. I practiced law in Navajo County for the last 28 years. I'm honored to represent the people that make up the Greer Coalition, a grassroots organization and people concerned and committed to the democratic process that will allow responsible growth, development, land usage, planning and zoning that is consistent with the laws, and that this body, in its wisdom, and for the benefit of all the peoples of the Greer community, has enacted. Specifically, I'm referring to the Greer Zone Ordinance, Article 6. I provided a copy of it to you. The most applicable part of it for today's issue is Section 601B1A. Quite simply, the parcel known as 021A is not been legally used as a resort, lodge, hotel, motel, or bed and breakfast, and therefore is not entitled to automatic designation as a Greer commercial resort zone. That is the issue before this body. The other part of the issue is whether or not this body is going to follow the erroneous recommendation of its staff that is based upon confusion and embellishment of historical facts and the dogmatic pursuit of allowing development that is built upon a series of mistakes. I would urge, first of all, that you consider the way this has been noticed. It does not alert the public appropriately because it suggests that there is a non-conforming use or conditional use on 021A. That is simply not the case. There is no such designation on it. The historical records within the county's own documents show that. When this body passed the law, the Greer zones made a promise. Made a promise to allow development consistent with what the law was and allowed for their use. However, if this is approved, that promise will not be kept. but there still is a way to allow the development to occur, and it's right there in Article 6 as well. It does allow for, following the 6 months public process, a public hearing will be held to adopt the zone map. Go forward. I would point out, however, that even with respect to item number 1 was on the agenda, even though you said that it will be reinstated, which maybe means out the issue, it wasn't discussed because Mr. Lowe was here. This is equally important, if not more important, and I would urge you to carefully consider what Mr. Weller would have to say had he been here. His comments are enlightening. He spent a good deal of time with us working on this, and he can provide excellent insight that will rise above the confusion and the misleading facts that have been presented before you. I would also urge you to consider that in addition to the fact that there is no 3-acre parcel, the documents that were presented to the planning and zoning back in 1995, consisting of the description was consistently 1.9 acres, not 3 acres. The McIntyre memo, the planning and zoning assistant or director, consistently referred to 1.9 acres. The description of the square footage is consistently 1.9 acres. He even warns that the expansion will have to be looked at very, very carefully. There is no subsequent CUP that is found in the file, and that 3-acre parcel that is in there is not dated, it's not signed, nobody has taken responsibility for that, it just sort of magically appeared. Furthermore, if there is an argument that's to be made in support of this, that there is a conditional use permit, we submit that it is lapsed. I would urge you to carefully consider what I provided to you in your packets found at Article 11 under lapse of a conditional use permit. After 1 year, if there isn't some diligent effort to get a building permit, begin construction, or occupy the premises, it lapses. If there's an argument that it's a pre-existing conditional use, I would also urge you to look at Article 11, Section 1107J2, because it does not meet the requirements there, because it far exceeds the value, exceeding 25% over what it was. Finally, if this is urged to be an amendment to a conditional use, once again, it doesn't fit because the expansion goes way beyond the 10% limit that is set forth in that statute. And again, that's Article 11, 1107K. So, in summary, either take the time to understand this, continue it, because there's a lot of material here, there's a lot of history that can't be explained in 3 minutes, much less understood in a meeting of this length, especially in the absence of supervisory letter. Thank you for your time, and your close attention. I appreciate it.
Okay, next person we have is Scott Rose.
He's on the phone.
Scott, are you on the phone?
I am, Chairman White. Thank you very much. This is Scott Rose with the Kavanaugh Law Firm in Phoenix. My address is 1850 North Central Avenue, Suite 2400, and I am also proud to represent the Greer Coalition in this effort. What this boils down to in this recommendation by the staff is to rely upon a site plan that was never the subject of a hearing, that magically appeared in the file at some unknown time by some unknown author with no date on it. And the rest of it is built upon pure speculation. What we do know for certain, however, is that there was a dated site plan in the file in 1995. And what we do know is that Mr. Donato, who was the applicant in 1995, said in his own words at that time that it is a 1.9 acre parcel, and he's looking to expand it in the future. That is in the minutes of the Planning Commission meeting in April of 1995. So at that time, Mr. Donato said that there would be a 1.9 acre development, and that anything in the future, meaning up to the additional 1.1 acres on O21A, would have to be looked at very carefully. That's what we know. What we also know is that the reliance in the staff report on this address of 82 Main Street is completely unfounded. In February of 2013, the present owner submitted a subdivision application that said that the address of this property was 84 Main Street. So we have it in the applicant's own words. This is not a legitimate basis on which to proceed. It is not a legal basis on which to proceed. So I would urge the board to deny this application. Thank you very much. I'd be happy to answer any questions.
Okay, thank you. No questions at this time. Next one we have John Freeman. Mr. Freeman is the sixth speaker, by the way. What do you reckon?
Thank you. Just before we start, let me be a little bit organized here. So, get things right. So, good morning, Mr. Chairman, Mr. Shirley. Thank you very much for allowing us to speak. We really appreciate your attention. So, with respect to being able to come before you today. My name is John Freeman. I reside at 47 Osborne Road, Arizona. I'm a registered voter, a taxpayer of Apache County, and also the co-president of the Bureau Coalition of GCI. This case is no longer about the question of GCI zoning. The facts of the case are settled. All of the arguments attempting to establish a legal position to zone parcel 10208-021A have been shown to be invalid in light of actual zoning documents and hearing records of Apache County. Those two packets you have in front of you clearly demonstrate that there is no lawful, legitimate basis in any imaginable way that this parcel should ever be considered for GCI. I'm very surprised that staff would even have the slightest idea of recommending it and putting you in this position. Key arguments proposed were commercial stables in the 1995 Act. Clearly, the stables were never on this parcel. If you look at your map, you'll clearly see that. Okay? The case is now about the rule of law. All right? Will the case be decided by the board on the facts by the rule of law? In this case, Article 6, resulting in a lawful decision, or will the board be perceived as capitulating to political pressures, groundless threats of litigation, and make an unlawful decision, right? If it's not lawful, it's been unlawful, as defined by Article 6. Here there are three choices. Approve the staff recommendation that deny GCR to 021A. That's a lawful decision by Article 6. Approve the staff recommendation, including 021A, which is unlawful with Article 6, which contains 021A's use. Now, right, it's not lawful. If some insurance agent or some insurance company were notified in the future that they're going to operate an unlawful use, and there had been an incident, right, and they found that it was given in an unlawful manner, there could be a problem for future owners.
Okay? Also, all of the other 27 parcels are tainted by that unlawful decision. So instead of being threatened by one litigant, you're now being threatened by 27, potentially. Okay? Or you could approve the staff recommendation and continue only O21A, so that you have time to give intelligent thought and see this detail instead of deciding on a, to be generous, erroneous staff report and an erroneous attorney statement. Thank you very, very much.
Thank you.
I deeply appreciate the opportunity to speak.
Okay. The seventh speaker, Bradley Grower.
Good morning. In these types of
I'm hearing
this is about limitation, possible limitation, and exercise of prior restraint on those people wishing to speak today, sir.
You continue to talk, then I'm not going to allow that, Charles. Sorry, man. Okay, that's we won't count that as a speaker. So if somebody else wants to, speak in opposition, that's okay. That's, as long as it pertains to what we're talking about right now. David Brown, this is, I believe, you're representing the Mr.
Good morning, Mr. Chairman, Supervisor Sandal. But it's pretty speaker. Can I go at the end of everybody so that I can just rebut at once?
Okay.
Okay. Thank you.
Marianne? So, is Marianne here?
I put in for another item. I just said I read my, for the city.
Oh, this is not pertaining to this
Not
particular.
pertaining to this.
Okay. Lorraine Vaughn?
I was going to speak on the call of the public, and I appreciate your reinstating it.
Okay.
Thank you.
Okay, well, there's any other individuals, that opposing this, I still have 3 speakers.
So we reserve that time, sir, for a rebuttal to Mr. Brown. Rebuttal.
I'm sorry, Mr. Whiting?
Could you speak up, sir, so we can hear you?
Well, this is not a court hearing, it's just, we're here to hear the people that are in opposition as well as those that oppose this. If there was a court hearing, then we would have a rebuttal. So it's, Mr. Brown, it's just in your support, it's not a rebuttal. I don't think he should be doing a rebuttal. Okay. I guess we have Lorraine, Mary, but those are on different topics. So in support of, I have, is Doug here? Which, I think, there's two of you that want to speak, so whoever wants to go.
Mr. Chairman, could I take both of our times, please?
You mean take Mr.
Yes, sir.
Yes, since the others take that time.
Thank you. I appreciate the opportunity to be here. I appreciate Board of Supervisors. I appreciate the efforts of the Planning and Zoning Commission and their deliberations. I appreciate the Community Development Director and his staff and the County Attorney's staff, all of which recommended approval of this item. I'm here, Supervisor Weller said there was nobody here in favor except for the applicant. I'm here not only on behalf of Mr. Sandall, but I'm here on behalf of the hundreds and hundreds of properties that the interests of my family own in Apache County, and the thousands of acres of property that I represent in clients that are interested in growth and development and prosperity in Apache County. That being said, we get a little bit of history, and it's personal history. The Apache County adopted the zoning code in 1985 and said everything that's there is grandfather, and then they had the Career Phase 1 in 1989. In that Career Phase 1, this particular property at that time, and since 1896 and 1915, has had 2 cabins on it. It wasn't vacant property, it wasn't residential. These are cabins that were being rented out over time. It was originally a school and a civic center. There were other commercial uses on the property, including the equestrian. The equestrian wasn't just on the 2 acres to the south, it was on this one also. The old hitching post is still there. It was, in my opinion, and my personal history, I've been to that property as a little kid and been on the horse, and it was the entire 3-acre parcel. The mistake that I believe that Mr. Martin and Mr. Rose are making is that they're relying on the 2010 ordinance. This property had vested property rights as of 1985 when the Career Phase 1 ordinance was passed. And that right was to be a non-conforming grandfathered use, and under the definition of the 1985 statute, it was a resort. If you had a fishing pond, it was a resort. You did not have to have a lodging facility. If you had an equestrian facility, it was a resort. So in 1985, this 1-acre parcel we're talking about was a resort, and it's been a resort ever since, because that's what the law is. It's a vested property right, and the government can't come in and take it away. That's called private property rights. That being said, this 1995 conditional use permit they're talking about, and version 1 versus version 2, and the 1.9 versus 3.1, well, in 1985, Mr. Donato hired me to represent him in accomplishing the purposes of the entire 3.1 acre piece of land. And if you look at the site plan, it has 2 ponds on it. One was on the south parcel, one was on the north parcel. There was only a small pond on the south parcel to start with. He wanted to make it an attractive resort and change the look of it, and so he had to have a pond. He wanted to put a pond on the north parcel, the parcel we're talking about. So he hired me and spent a lot of money. I've got my old file right here to get a water right for that second pond. The old pond had an 1896 water right. And I represented for several years, and we worked on it. We're still working on that water right. They take a long time. Mr. Donato was a smart developer. He showed me the 3.1 site plan when I worked on it. That had the 2 ponds on it. He wasn't the kind of developer that was going to build out the whole property under the 3.1 site plan and ignore the 1.9 site plan just willy-nilly. He spent millions of dollars developing that property. He followed the 3.1 plan, and so did the county for the last 19 years. So in my opinion, it's clear that Mr. Donato followed the 3.1 site plan, and so did the county. They issued a total of 16 building permits over the last 19 years on that site plan. Number 1. Number 2, it doesn't matter, however, if the 3.1 was not the site plan that was approved by the board in 1995, because the ordinance that you passed in 1989 clearly says that when an owner of property that's adjacent to another property acquires the adjacent property, then he can expand that CUP automatically onto the new property. That's clear in 308, section 308 of the Career Phase 1 ordinance. And so it's legally clear that the CUP applies to the entire 3.1 acres under either theory. So Mr. Donato relied on the county and the 3.1 site plan, because that's how he built it. He didn't build anything that looks like the 1.9 plan. That plan had a building on top of the well. That couldn't work. That plan didn't have an art gallery. Mr. Donato built an art gallery. He relied completely on the 3.1 site plan and built it accordingly. Then along comes my client in 2006. By the way, I didn't get along with him when I was sitting in your seat. But that's neither here nor there. But on this case, he came to me and I says, you have a righteous case, and I'm going to take it because I don't do zoning issues. But he comes into Milton and says, Milton, before he buys the property, I want to spend $1.5 million buying this property. What can I do with the property? And Milton hands him the Tom Donato CUP along with stapled to it the 3.1 map. And so he spends $1.5 million and then continues to build out the CUP, which is interesting because I don't understand why the Grid Coalition would rather have 14,000 square feet of buildings on 1.9 acres instead of expanding it over 3.1 acres. It makes it better, makes it less dense, and makes it more open space, and it only has a coverage of about 10.5, maybe, 11.5 or 12% building coverage.
Okay, time's up.
Can I use have I already used Mr. Sandals also?
Yes, sure.
Okay. I would just urge the board to understand private property rights, growth and development, and reliance. Thank you, Mr. Chairman.
Okay, thank you. Okay. Mr. Whiting, now that we've heard. Okay. Is there anyone else in the public that's in support of this? We already used your time, sir. That was already, ma'am?
I'm in support of it, I don't want to speak.
Okay, yeah. Anybody else? Okay. We're trying to be fair, to the speakers, so. Now that we heard everyone speak, I just want to make sure, we're clear on this and there's no misunderstanding for the record. So this public hearing, is it just to approve this one item, or is there other items? Mr. Whiting, could you please explain the community development to us?
Sure. Mr. Chairman, it's just the public hearing that was noticed for these parcels for the share outside of us. If there's no one else wants to speak, then let's close the public hearing. Proceed.
Okay. We don't need a motion, but I like. Do we need a motion to close it? Okay. With that, I'm going to go ahead and close the public hearing. Now, is there a motion for the approval of the Greer zone map?
From down south Apache County out there in Lee. I'm not sure how many years I've served with him. Prior to my ascending to the presidency of the foundation, I served as Apache County Supervisor for 18 years. And most of that time, I served with the gentleman, the late Officer Henry. He was a real gentleman. He and I used to visit and we used to talk. And sitting here, running these meetings, talking about different issues, he always said that property rights is almost a sacred thing. It's not a sacred thing, it's a sacred thing. Who are we? Who am I to try to get in the way of development, of trying to tell somebody what to do regarding their property? If it's their property, they have a right to it. So I'm not going to be in the way, and I don't want this board to be in the way of that private property. And I've seen him take action, even controversial matters, in the affirmative, going by that philosophy, going by that manual that he had, that value that he had. And I respected that. You know, it takes me back to them. I see the same thing going on. You're talking about property rights. Like I said, my late colleague, property rights are sacred. So, given that, I don't want to be in the way. Not using the property rights, not using the property. It sounds like there's a lot of money put into it already. It sounds like there's you go back, way back. It sounds like it. And as far as I know, it seems that everything is in order. Well, the county manager has done his job. Planning and zoning have done their job. County attorney has done his job. So given that, Mr. Chairman, I'll go ahead and move that we approve this particular item that's before us.
Okay. I'll second the motion. And I do feel similar to what Mr. Shirley has stated. You know, up north, you know, we're in need of community development. We are in need of development up north. And I really wish, you know, businesses would come over and say, hey, I want to open up convenience store, any business, rather than for our people to go to Gallup to purchase food, whatever is needed. You know, they have to travel to Gallup, Flagstaff, Farmington. You know, we're in need of economic development. You know, with somebody like Mr. Sandal would, you know, say, hey, you know, we'd like to open up a store or whatever is needed up there. And you know, I feel the same way. You know, we can't deny progress. This place, you know, there's a lot of progress taking place. Go to Phoenix. Every day there's development. The freeways are being expanded. Go to Flagstaff, Albuquerque. That place is growing, and we can't be in our way of, you know, somebody wants to expand. So with that, I'm going to second the motion. We'll go ahead and call for the question right now. All in favor, say aye.
Aye.
Aye. Opposed? The ayes have it. 2 in favor and opposed. Okay. Item 3. Consent item, Mr. Wingert.
Mr. Chairman, the consent agenda consists of items A through C, and we recommend approval.
Move that we approve it.
There's a motion to approve. Go ahead and second the motion. Questions, comments?
Mr. Chairman,
Mr. Wingert.
I believe there was somebody that wanted to address item C. Is that correct?
Only if I need to. I just told that I needed to show up to speak to it. No. That was from Mr. Alton.
I don't know that there's a need for discussion. This is something that we've done in the past for the Career Civic Association, is to waive the temporary use permit fee so they can have the function.
Are you supporting this?
Yes.
Okay. Well, if there's a question, ma'am, we'll call you or whatever. Okay, for the consent item, there's a motion and a second to approve. All in favor say aye.
Aye.
Aye, oppose? The ayes have it, 2 in favor, none opposed. Thank you for showing up. Number 4, engineering.
Good morning, Supervisors.
Good morning.
For this morning. Before you, I have discussion of possible approval of a 5-year contract extension to sell the project. The terms of the contract are for the purchase of limestone material from our limestone quarry. This is the same contract that we've had in place for the past 5 years. No terms have changed in that contract. This has been reviewed by the county attorney's office and recommended for approval. One note I will bring to you is that listed on the contract is a vendor ID number as well as the vendor title. There's some confusion there. They list that this is Apache County Sheriff's Office. It's not Apache County Sheriff's Office. It's for engineering or where this could be. And the PO box is different. So I would recommend approval provided SRP changed the title and the PO box. To make that correct.
Okay.
Whatever your choice is.
Put the motion to approve. I'll second the motion. All in favor say aye.
Aye.
Aye, opposed? The ayes have it, 2 in favor, none opposed. Number 6.
This item, Supervisors, is a discussion of possible approval to apply for a Resource Advisory Committee funds for County Road 3140 and County Road 4140 for the application of magnesium chloride. Both of these routes have received this RAC funding in the past for the placement of limestone roads that are located on the National Forest where we have what we call an easement. We feel like we have a good possibility of receiving these funds again, and we recommend your support and approval of this application.
Okay.
Move approve.
Motion to approve. I'll second the motion. Questions, comments? All in favor say aye.
Aye.
Aye, opposed? The ayes have it, 2 in favor, none opposed. Item 6.
Item 6, Supervisors, is a discussion of possible approval to purchase a new 2014 North Professional 16-tire lowboy. This is for hauling heavy equipment in District 2. They are offering with this purchase a trade-in. Their older lowboy, a 50-ton Eagle Beamer lowboy. This purchase would be the dollar amounts. The information is listed in the agenda. The price is $101,350. The trading value is $21,000 for a total of $84,467.50. We will be using PERF funds, and we will be utilizing the National Regional Purchasing Alliance contract, which we are party to. This has also been approved by the county attorney's office.
Okay. I just want to add that the one that the lowboy that we have is unsafe. There's been a lot of repairs made on it, and we feel that we don't want to haul any other equipment on it, so it's better just to get a new one and trade in the old one. So that's the purpose for requesting this purchase. Is there a motion?
So moved.
Motion to approve. I'll second the motion. All in favor say aye.
Aye.
Aye. Opposed? The ayes have it, 2 in favor, none opposed.
There's no other business, Chairman. We approve adjourn.
Okay.
The Board of Supervisors.
I'll second the motion. All in favor say aye.
Aye.
Aye. The Board of Supervisors meeting is hereby adjourned. Thank you.
Sure. Thank you so much.
Really welcome. Sure.
They need those revenues because we don't make I don't know anything anymore. Friendly, $1,000.
It'll work.
Because I got it on video, they settled, but they're out of court for $80,000. I'm not ready to go that far with these guys yet, but they're really bye-bye.